Question 151. ASUB. A sues B for the possession of Math property as an heir of Math. The suit is dismissed on the failure to the production of succession certificate. A. File a subsequent suit as a manager of the Math. If the suit is barred, the second suit will not barred by the res judicata. The rule of constructive res judicata applies to the writ proceeding, however does not apply to the writ of habeas corpus. Constructive res judicata contain which of the following explanation? Explanation 4 of section 11. Any relief claim in the plaint which is not explicitly granted by the decree shall, for the purpose of this section, shall be deemed to be refused. This provision incorporated in section 11 explanation 5. Petition to the Supreme Court under Article 32 is subject to the rule of res judicata except writ of habeas corpus. Res judicata means not try the suit if suit involves a similar issue between the similar party to be decided. Doctrine of res judicata is contained in section 11 of CPC is based on the maxim interest replica ut sit feci litium. The order passed without the jurisdiction attained finality in the favor of some parties. Whether the principle of res judicata under CPC would apply to such order between the same party? No. The principle of res judicata applies to between co-plaintiff, between co-defendant. A decision in a suit may operate as res judicata against a person not expressly named as a party to the suit by the virtue of explanation 6 of the Code of Civil Procedure. The provision of res judicata also apply to the execution proceeding of a decree. Yes, explanation 7. The principle of res judicata is mandatory. Which one of the following conditions must satisfy in order to apply the rule of res judicata between co-defendant? The question between the defendant must be finally decided. The doctrine of res judicata is contained in section 11 of the code based on the maxim nemo dept lis vixere pro uno id causa interest replica ut sit feci litium. A suit was filed and disposed of by the court which had no territorial jurisdiction to try it. That judgment and decree became final. Whether the finding records in operate as res judicata in the subsequent suit between the same party? No. The principle of the private international law of incorporated in the section 13 and 14 of CPC. The validity of the foreign judgment can be challenged under section 13 of CPC in a civil court only. Under section 13 of CPC, which one of the following judgments shall not be conclusive? Judgment not on merit, judgment founded on the breach of Indian law, judgment against the international law. A foreign judgment not covered by any of the exception under section 13 of CPC shall be dash as any matter thereby directly adjudicated upon the between the same party conclusively. Section 14 of CPC enacted that a court shall presume upon the production of certified copy of a foreign judgment that such judgment was pronounced by court of competent jurisdiction. That presumption is rebuttable presumption of law. On the production of certified copy of the foreign judgment, the presumption as to the competency of the court under section 14 of CPC is rebuttable presumption of law. This section of CPC declared that the court shall presume, upon the production of the document purporting to be certified copy of foreign judgment, that such judgment was pronounced by the court of competent jurisdiction unless the contrary appeared on the record is proved. Section 14. Under Section 15 of CPC, every suit shall be instituted in court of lowest grade competent to try it. Where the local limit of the jurisdiction of court is uncertain, the place of institution of suit shall be decided according to the provision of Section 18 of CPC. Suit relating to immovable property can be filed under Section 16 of the Civil Procedure Code within the meaning whose local jurisdiction is the property is situated. Suit for the compensation of wrong done to a person or immovable property. Where the wrong was done within the local jurisdiction of one court, defendant reside within the local limit of the another court, either A or B, at the option of the plaintiff. Which one of the following statement is true? A suit for recovery of immovable property shall be instituted in a court in whose jurisdiction the property is situated. An immovable property held by Y, situated at Bhopal, at the wrongdoer personally work for gain at Indore. The suit obtained for the compensation of wrong of the property instituted in either Bhopal or at Indore. A suit relating to immovable property shall be instituted at a place where the pro is situated. A suit for the partition of where the property is situated. Suit for the partition of immovable property instituted in a court where subject matter is situated. Subject to the pecuniary or other limitation of the suit, recovery of the possession of immovable property must be instituted in the court of within whose local limit the jurisdiction of property is situated. X is living in Pune, Y is brother in the Mumbai. X want to file a suit for the partition of their joint property situated in Bangalore and Delhi. The suit may be instituted either Delhi or Bangalore. Suit for the partition of immovable property may be instituted in where subject matter is situated. Where may suit for the partition of immovable property is instituted? Where the subject matter of property is situated. A suit relating to immovable property where the property is situated shall be instituted at place where the property is situated. Under Section 16 of the Code of Civil Procedure, suit relating to immovable property can be filed in a court within whose local jurisdiction the property is situated. Which one of the following is a leading case on exclusion of jurisdiction of civil court? Dullabhai versus State of Madhya Pradesh. The place of institution of the suit in respect of immovable property situated within the jurisdiction of different court has been provided under Section 17 of CPC. The local limits of the jurisdiction of court is uncertain. The place of institution of suit shall be decided according to the provision of Section 18 of CPC. Section 18 of CPC provides for place of institution of suit and respect of immovable property where the local limit of the jurisdiction of court is uncertain. Where the local limit of the court of jurisdiction are uncertain, the place of institution of suit shall be decided by Section 18 of CPC. Which one of the following is correct statement so far as the Section 20 of CPC is concerned? Suit has to be instituted in the court of lowest grade competent to try it. Suit has been instituted in the court within the local limit of whose jurisdiction defendant actually and voluntarily reside, carry business or the personally work for gain. Suit has to be instituted in a court within the local limits of whose jurisdiction the cause of action is wholly or partly arise. CPC applies of whole of India except Nagaland and tribal area. Mohan residing in Mumbai beat Sohan in Delhi. Sohan sue Mohan in either Mumbai or Delhi. A suit shall be instituted in court within the local jurisdiction of whose the cause of action in part arises. A suit for damages for the breach of contract can be filed in the place of where the contract has been executed, where the contract was performed. A corporation under Section 20 of CPC deemed to carry business at its principal office in India, its subordinate offices in India. A residing in Mumbai published a statement defamatory against B in Delhi, where can B file a suit for the compensation against A, either Delhi or Mumbai. General principle of waiver that provide the failure of the rise of objection of the court of the first instance at the earliest opportunity shall prevent the defendant from arising such objection in the subsequent stage. The judgment would not be validated on the ground in the absence of territory of pecuniary jurisdiction is reflected which provision of the CPC section 21. According to section 21 of CPC, when can objection as per the place of suing can be taken before the court of first instance at the earliest possible opportunity.